We just got ourselves a breaking news update in the Ripple versus SEC lawsuit. And of course, the moment that it came out, I let everybody know over on Twitter, which was about 25 minutes ago. And so if you've not done it yet, make sure you go ahead and press that like button. But the only reason I didn't go and make a video instantly is because I wanted to wait for some lawyers to respond. If I made a video second one, we'd basically have no more info except for this. Ripple files their opposition to the SEC's motion to certify interlocutory appeal. Which again, the summary of that is the SEC is trying to appeal the decision that the judge made with regards to how Ripple sold XRP. The whole issue at question is not whether or not XRP is a security itself. It's about how, in some instances, Ripple sold that XRP. For example, over exchanges, the SEC seems to think that if you sell crypto over exchanges, that's still some sort of investment contract. The judge said, nah, that's not true. But again, that's the main reason the SEC is trying to get this decision changed. And so Ripple came in to say, no, we don't think you have the right to try and change that now. Again, the SEC will inevitably get a chance to appeal all the way as the lawsuit is over, but what they're filing for right now is to file it early while the lawsuit is still ongoing and before a lot of depositions take place, before a lot more research takes place. That's the issue at question. Whether or not they should be granted the right to, instead of waiting all this time, go ahead and fight it now before anything else and basically put the rest of the lawsuit on hold. Here's Ripple's own legal team, which basically said, Ripple just filed their opposition to the SEC's request for an interlocutory interim appeal, which again basically just states that the SEC will eventually get the chance to appeal, but they want to do it early, right? Interim, in the middle of everything. Worth the read, in my opinion, especially the footnotes. Footnote 5 is one of my personal favorites. And I'll take a look at what Cowboy had as a response to it. The court did not rule in the SEC's favor on all issues. In response, the agency is now rushing to appeal what it claims is purely legal question applicable to every digital asset case. And again, the reason that that's so relevant is because the SEC is saying this has such urgency, it needs to happen now. It's a legal question, basically. But this is not what they were claiming earlier, and them wanting to extrapolate it to all these other cases is actually a pretty funny aspect, because in theory, the moment that they do lose, which I believe is inevitable, that statement is going to hurt them way more than it could have ever gained them. But hey, that's my own personal opinion on the matter. But the SEC's latest shift of litigation positions to further its desired goals, like its earlier ones, shows no allegiance to the law. Docket number 531 at 6. The exceptional circumstances required for interlocutory appeal are absent. First, the court's summary judgment order does not present a controlling question of law suitable for interlocutory appeal. So again, on that baseline already, this appeal, interlocutory one, should not be granted. Second, the supposed substantial ground for disagreement, which the SEC alleged, is merely the SEC's dissatisfaction with the court's application of Howey to most of defendants' transactions in XRP. So again, the SEC is trying to say, we're not happy with the way the judge basically interpreted the law, and they're trying to say that it's just a very, very difficult question that other judges disagreed, like the one in the Luna case. But Ripple's response is saying the judge made a clear decision, backing it up properly, and you're just not happy with that. It's not something difficult to assess, though. It's just you not being happy. And again, as a response to it all, I'd personally like to state, if the SEC always says the rules are so clear, how can you ever say that this is a point of disagreement then, or something along those lines? When, well, it shouldn't be up to one's interpretation for it to be basically wrong. If everything is so clear, everybody would have basically the same opinion, I think. And third, the SEC concedes that protracted litigation is necessary, regardless of whether its required interlocutory appeal succeeds, meaning certification has no chance of hastening the end of this litigation. Independently, the court should also deny the SEC's request for a stay, which is basically to put the entire lawsuit on hold, the rest of the lawsuit. The SEC has not even attempted to meet the standard for a stay, even after the individual defendants identified that omission in their pretrial motion letter The individual defendants write separately to oppose the SEC's request, and Ripple joins that opposition. And what that last piece was referring to is that Brad Garlinghouse and Chris Larson officially are two separate entities in this entire lawsuit, right? The lawsuit from the SEC is partially against Ripple, partially against the CEO and co-founder, Chris Larson and Brad Garlinghouse. And so they almost always also file things a little bit separately, especially because in this case here, they have different motives. Well, rather, that the Ripple lawsuit part is over, but the Brad Garlinghouse and Chris Larson lawsuit part is still ongoing. And so from them specifically, putting the entire lawsuit on hold would definitely burden their entire personal lives a lot, etc., etc., etc. Whereas with Ripple, it doesn't necessarily change that much. So in theory, they should also have a different response to why this intellectual appeal is such a quote-unquote bad idea. John Dean had this to say, he's a lawyer, very well known in the community. As expected, Ripple demonstrated that an intellectual appeal here is simply not warranted. The SEC has always maintained Howey is a fact-specific inquiry, and for an intellectual appeal to be warranted, the Second Circuit should not have to review the extensive factual record. Footnote 2 destroys the SEC's argument on this matter. And Ripple then quotes, the SEC has made similar averments in other cases. Motion to dismiss 24 in the SEC v. Green United case on June 30th, 2023, arguing in opposition to defendants' motion to dismiss that this case is not about all digital assets, it only concerns defendants' crypto assets green, and that every crypto along with issuance thereof is different and requires a fact-specific analysis. And the reason that this is such a strong base already is because they try to state that whatever is happening in this Ripple lawsuit is so important for all the other ones. But in theory then, following their own thoughts, everything that happens in this lawsuit, well, it's all basically about all the circumstances, whereas they're now trying to deny that. But so anything that happens here doesn't necessarily have to extrapolate to any other lawsuit, so why the hurry? Because, well, XRP had a certain set of circumstances that all these other ones won't have. That's the next part afterwards. It has done the same in statements to the public. Whether a particular digital asset at the time of its offer or sale satisfies the Howey test depends on the specific facts and circumstances. Whether or not a particular transaction involves the offer and sale of a security will depend on the fact and circumstances, including the economic realities of the transaction. And William Himmons said it before as well. Legal analysis must follow economic realities of the particular fact of the offering, and that whether a digital asset is offered as an investment contract will always depend on the particular facts and circumstances. Point being, they can't go back on their word now. But again, who are we to expect the SEC to do anything different, right? And footnote number 6, just for good record, it's not perfectly centered, but I think it'll do. The SEC also refers at 13 to the Terraform court conclusion, which I just talked about, that secondary market purchasers had taken the SEC's alleged facts as true, as good a reason to believe that the defendants would take their capital contributions and use it to generate profits. Although defendants believe that secondary market transactions are not securities transactions, and further believe that this court's reasoning supports that view, this court expressly reserved that question for decision in another case that present it directly. So they're basically saying that that legal piece is not necessarily the topic of this lawsuit as a base topic, right? And so they're answering that in a separate issue. See Order 23 and 16, stating that the court would not address whether secondary market sales of XRP constitute offers or sales of investment contracts because that question was not properly before the court. That's not what the SEC alleged at the start. And that whether a secondary market sale constitutes an offer or sale of an investment contract would depend on the totality of circumstances and economic reality of that specific contract, transaction, or scheme, which again, the SEC themselves stated in the past. Point being, hopefully the SEC is going to get destroyed yet again. Intellectual appeal could actually be nice because it puts the SEC in an awkward spot where, well, they're going to officially get denied, and now there's no more way for the SEC to get back to whatever they wanted. So from that perspective, it's very nice. On the opposite end, well, it holds things up in the lawsuit for Chris and Brad, which is not so nice, and I just don't want to see the SEC win, all right? Even though the appeal might actually be worse for them, I just don't want to see them win. Because they're going to spin it saying, hey, you see, the judge understands how crucial this all is for us to set the record straight, yada, yada, yada. And I don't like them getting that satisfaction. In theory, I'd prefer to get this appeal out of the way later because in the meantime, we're going to see so much more people come forward with their stories, with everything, and many other lawsuits are going to conclude. yeah, I just prefer to get it later because I think that'd be more wholesome. And I prefer to see the SEC get slapped in the face harder later than a soft slap right now, even though I think the slap in their face is inevitable because the SEC is crooked. It's going to lose everything and yada, yada, yada. But hey, that's just a little update for right now. Hopefully you guys all enjoyed it. Put that notification bell on if you want to be notified every single time something crazy happens. That's about it.